Today, we are in the Group 5 presenting the case of EGV Realty and CRISTINA Condominium versus Court of Appeals and UNISPHERE.
On November 28, UNISPHERE's unit was allegedly robbed with various items valued at 6,165 pesos. Then another robbery allegedly occurred on July 2. Both cases were reported to the CRISTINA Condominium. Then on October 5, respondent demanded compensation and reimbursement from CRISTINA Condominium for the loss incurred. The latter denied any liability, stating that the goods lost belonged to Amtrade, a third party. As a consequence of denial, UNISPHERE withheld payment of its monthly dues.
UNISPHERE received letter from petitioner demanding payment of past dues. Then, on December 5, EGV Realty executed a deed of absolute sale over Unit 301 in favor of respondent. On December 12, CCC and EGV filed a petition with Security and Exchange Commission to respondent's failure to pay the 13,142 pesos.
In response, respondent alleged that he is not in default of the said monthly dues because of the petitioner's failure to provide security in the said premises, in which would have probably prevent the robbery from taking place. Wherein, according to respondent, petitioner must now pay 12,295 as damages. UNISPHERE filed a notice of appeal to the Court of Appeals on September 10. The Court of Appeals decision was that the respondent's monthly dues must be offset by the losses the UNISPHERE incurred due to the alleged robbery. Therefore, respondent was ordered to pay petitioner 847.67, which is the remaining balance after offsetting, with a 12% interest per annum. The instant petition for the review in the Supreme Court was that under the procedural aspect, the Court of Appeal did not acquire jurisdiction over respondent's appeal because it failed to comply with the prescribed mode of appeal. Moreover, SEC and bank order has already attained finality, in which must be likewise final and executory.
In the substantive aspect, petitioner claimed that the ruling of the Court of Appeals on the offsetting of the parties' claims is unfounded. In accordance with Article 1278, compensation or offset undertakes place only when two persons or entities in their own rights are creditors and debtors of each other.
Petitioner denied such debtor and creditor relationship since the respondent was not the owner of the lost goods. Such reimbursement must be made against the security and not the corporation. Also, there was to agreement that the unit owner will be indemnified for incurred losses. In the Court of Appeals, they decided to offset the respondent's monthly dues with the reimbursement which was allegedly be made against the petitioner. However, according to the Supreme Court, such offsetting is not proper at the case at bar.
Wherein according to Article 1279, there are certain requisites in order to consider compensation as proper, which are stated on the slide.
Since the respondent failed to prove the existence of such requisites, compensation may not take place. We must consider that what the respondent has against the petitioner is just a claim. Only debts are enforceable in court. Claim is merely the evidence of debt and must pass through the process prescribed by law before developing it into a debt.
It was not proven that the petitioner was truly indebted to the respondent since the validity of one's indebtedness must be admitted by the alleged debtor or must be pronounced by a competent court, in which did not happen at the case.
There was also a lack of evidence to show that the parties are mutually creditors and debtors to each other.
Since it was mentioned that the parties are not mutually debtors and creditors to each other, the act of offsetting or compensation made by the Court of Appeals was not proper, since it would be in violation of the Article 1278 of the Civil Code.
Therefore, the court's ruling is that the Court of Appeals made an error in ruling that the compensation or set-off is proper at the case at bar. Then, the order of the SEC reiterating the hearing officer's order was reinstated, so ordered. And that concludes our case analysis. Thank you and God bless.